Welcome to the Case Autopsy, the Verdict and Settlement podcast with your host, Mike Campbell. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your hosts, Mike Campbell and Chris Finney.
Chris, what's going on, brother?
Mike, how you doing?
Not bad, man. Not bad. Got a couple trials coming up, so I'm starting to get in sort of that mode. You know what that mode's like.
I know. And then it always takes a little bit to get into that mode, but once you get there, like, this place is great.
Yeah. And then when you don't have trials for a while, John in my office, I remember said, "Are you just looking for conflict? Is that like..."
Yeah, probably. Yeah.
You know?
So
yeah, I'm looking for something to do. I get antsy and I like being exhausted, I guess is the best way to put it, because it slows my mind down. So I'm almost there. But how are things going with you?
no complaints, same trials coming up, and getting back in that mode, which is great, but you got to build it back up, and looking forward to getting in front of people, and especially who we got on next is Wes Shumate, really $177 million on a assault case against a large hotel chain. We've heard about this case. It was all over the place around here. I'm really interested to hear how they put it together and how actually the case played out.
Yeah, absolutely. Well, let's hop to it.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
Hey, Wes, how's it going?
Good, man. Thanks for having me on.
Yeah, you got it. Hey, you just had an outstanding verdict, and I'm glad that we get to sit down and talk about it today.
Oh, yeah, I'm glad you reached out. Honestly, I hadn't known about the podcast until you reached out, and now I've been through every episode, and you need more.
Oh, yeah, well,
You got to get to work, man.
We've now got 3 viewers, me, Chris, and you. So that's great. I appreciate your loyalty to the program. Why don't you tell all listeners a little bit about your practice and where you practice and what kind of cases you work on?
Sure. And since 2008, actually longer than that, since I started law school, I've been with Davis, Bethune, and Jones here in Kansas City. I know local Missouri guys might know this, but so Scott Bethune that I work with and who tried this case with me is my older cousin. And
oh, no kidding. I had no idea.
Yeah, well, he tries to keep it quiet.
I thought it'd be the other way around.
Right. No, so I transplanted here for law school from Tennessee, and because of Scott, and then so I've always, except for about a 3-year hiatus back to Tennessee right after law school, I've been a plaintiff's attorney. We've done just about every type of plaintiff's case I can imagine since I've been here, and keep doing it. We handle trucking cases and a lot of train related cases, both from the FELA worker standpoint and crossing cases. I think we're some of the few that do both of those. Pretty much anytime someone or some group has been wronged, we try to handle the case, and if it's interesting, we take it on. We've handled cases where the local power company has messed up a levee and flooded out some farmers in western Missouri, all the way to, your regular car wreck cases that a lot of us are familiar with. So being here with Scott, and of course, Grant Davis, Tom Jones, all those guys, I get to see things that I would never see anywhere else. So it's been pretty good the past, I don't want to say how many years, but too many so far.
And I can tell you, and I think Chris would confirm this, being active on the Missouri Association of Trial Attorneys listserv, anytime there's in particular a big FELA verdict or a large verdict on that side of the state, we'll either see your name attached to it or Scott or Grant's or Tom's name attached to it, and so you have a history of success there.
No, I appreciate it. I got really lucky to be able to settle in with a good group of guys to learn from, for sure.
Yeah. And this case that you recently had in was it St. Louis County?
St. Louis City.
St. Louis City.
Yeah, it was in the city.
Chris will know this. That's
Yes.
his neck of the woods.
Yeah.
Why don't you tell us what you can about how you started working on the case and just a general overview of the case itself?
Yeah. So really an interesting part of the case to me is our client Shannon. First of all, she is absolutely wonderful, strong woman. It took a hell of a lot of courage for her first to come forward about what happened to her. I'll tell you a little more about that later, but she's a sheriff's officer on the East Coast and has been. She was actually in St. Louis, and this is back in April of 16. So she's there for a homicide convention. They were doing a medical legal death investigation seminar that week. She and a coworker had flown out. And I guess I'll get to the short of it first, and then we can go about the details. But the short of it is, after the first day, she and her coworker came back. She was in her room. He couldn't get a hold of her and called for a welfare check, like where someone from the security department comes to check on you, which after a series of policy violations led to the security officer returning later after the check and sexually assaulting her in her bed. So, not only was it a sexual assault, not only was it an awful thing, but this guy knew she was a police officer, law enforcement officer, when he went in. So it was pretty brazen, the attack. But the way it came to our firm, she needed some coworker support just to report the incident. And once that was done and the criminal side began, one of her other coworkers, another sergeant, was encouraging her to find a civil attorney in Missouri. And they started looking around. They called our office, just calling around. I think just internet searches, and found out that Scott Bethune, my partner, my co-counsel in this case, his dad was a sheriff in New Madrid County, Missouri, in the 80s and 90s. It's my Uncle Jake. And when she found out that, she thought that was a good sign that we had a connection, because she worked for a sheriff's office. Scott's dad, my uncle, was a sheriff back in the day, and she ended up feeling more comfortable with us because of that, and we got into the case.
So, well, when did she disclose that this incident happened? Did she go the next day, a week later? I assume she went to St. Louis Metropolitan Police Department first.
Yeah, I'll tell you. So just to give you the timeline, they had gotten to town the day before. And one of the things they did was, well, Chris, that Mike, you'll know this too, but downtown, a lot of times they have the horse and carriage rides around downtown. So they just thought it'd be fun. And they hopped in one of those and went over to a store close to the Hyatt down there and got some toiletries and stuff for their different rooms. And they got a case of water bottles just to have it, and put it in Shannon's room. She's in room 911. Her coworker was like in 908 down the hall. And so the next day they had gone all day seminars like we do, sat through that, met for a drink at the bar there in the hotel and an appetizer. From there, they went over to see the Cardinals play the Cubs. Unfortunately, those guys from Chicago won that day, but it happens every now and then. And had a couple beers at the game, met some people at the game, and went to a local jazz club to hear some music. And then about 11, they came back to her room. They get back to her room. He goes in and gets a couple water bottles and goes to his room. She says, "I'm going to take a shower and go to sleep." He gets back to his room and realized he can't find his work cell phone. He had a sheriff's department issued phone and a personal phone. And he thought, I probably set it down over there. So he walks down and knocks on her door and hears her shower. Goes back to his room, waits 15 minutes and calls, and she doesn't answer. Then he called the room and she didn't answer. And then he went to her room, showers off, still no answer. And at this point, he starts to get worried because he remembered a conversation from earlier the day about not having a sticky pad on the floor in the shower.
Oh,
grip
yeah,
pads.
yeah.
And he's thinking they're there for a medical death investigation seminar. So he's starting to freak out a little bit and calls the front desk for this wellness check. And we can talk about what happened during the wellness check later, but that, like I said, was what ended up leading to a sexual assault after several policies weren't followed. So the next morning, the assault happened around midnight. The next morning, around 6:30, he comes by her room, her coworker does, and they go to breakfast and they go to the seminar. When he came by the room, he said, "Look, you're going to kill me. I have something to tell you." And she said, I know, somebody came by the room. He says, "Yeah, I'm sorry. I was worried about you. I had a wellness check done." And she said, "Okay. Did anybody else come in the room?" He says, "No." She says, "Were you there the whole time?" He says, "Yes," because he was standing in the door as it's happening. So they go downstairs, and after a little while, it's bothering her. And she says to him, "Look, somebody came back and touched me. Was it you?" He said, "No, I didn't do that." And she said, "Well, this is bothering me because somebody came back and touched me." And at that point, this is around 8-ish in the morning, they go to the front desk to report it.
Mm-hmm.
So, just to get a little more into that, what happened to her, she's laying on her bed. She's asleep. I mean, I mentioned that they went and took the horse and buggy ride. She's terribly allergic to horses. So she had that going on, and she had taken some allergy medicine. They had had a few drinks. Been a long day. So she went to bed and she was out. She was sleeping. When the security officer came for the welfare check, her security latch on her door was latched.
That thing on the back that we always like clip closed or whatever, that you can open it about 2 inches or whatever it is. Like
That's right.
That's what you're talking about. It's about eye level and you flip it shut.
That's right. Yeah. And the one at this hotel was the one like on the door, it has a peg and then it has like a U shape, like a horseshoe arm that swings over it.
Yeah. Not the chain, but like the actual heart. Yeah. I know what you're talking about.
Yeah. So she was safe and secure, she thought, in her room and went to sleep. So as she wakes up later she's on her side in the fetal position. I mean, look, I'm in this little tiny Zoom square and I'm trying to show you.
Yeah.
Right.
So she's lying on her side on the bed with her back to the edge of the bed, right? She's wearing tights and a t-shirt. Her legs are together. She's in the fetal position. When she wakes up, this man has leaned over the top of her and had his hands between her legs, as she put it, rubbing forcefully. So she turns and looks up, and she says her legs were paralyzed. She was so scared she couldn't move her legs. She turns and looks up, and he just stood up, and it's dark. He stands up, and then he's gone. And she couldn't remember if she heard the door shut. In her mind, she never heard a door shut behind him. So her first thought was, "Oh my God, I was just attacked and somebody's still in here with me."
Mm-hmm.
So she got up, turned on all the lights, checked the shower, checked under the bed, checked everywhere. No one was there.
I mean, this is like a harrowing 30 seconds. I can only imagine like what that feels like you're searching your own room for someone you don't know who's in there.
Yeah. And to her at that point, if you think about when you're dead and asleep, someone or something, I mean, she doesn't know what this is.
Yeah.
You think about how irrationally you might be when you're completely in a deep state of sleep and then boom. And so she's turning on the lights, she's looking around, and she ended up going just lying back down the bed in a total panic. And at some point she did go back to sleep. And she's questioning herself by that point.
Sure.
Like, what the hell just happened? What was that? Did that just happen?
Did she call anybody at that point? Like, is she married or siblings or anything, or no?
So Shannon, at that point, she was in a relationship with her son's other mother.
Okay.
And she was back home in New Jersey, and on the East Coast. She's back home, and while she was awake, she just sent a text message and said, "I want to come home."
Hmm.
But she couldn't figure out what happened, or if something happened, or in her mind, she's starting to really doubt herself. The panic is there, and she couldn't, being a police officer, she couldn't come to terms with, and still today has trouble coming to terms with, how does something like that happen to me? I'm a cop.
Mm-hmm.
And so she just was lying in bed until she drifted off to sleep and woke up the next morning to go to the seminar.
Mm-hmm.
And I'll tell you this. So we, at trial, one of our experts, we had two experts at trial, one for the PTSD damages and one for just to talk about foreseeability of this type of assault.
Well, tell
Yeah.
us what your actual claims were against I guess it was a hotel employee or a security agency that worked for the hotel. And so what were your actual claims, and who were the defendants, I guess?
So at trial, the only defendant was Hyatt Corporation.
Okay.
It's Hyatt Corporation doing business as the Hyatt Regency St. Louis at the Arch.
Okay.
That the Hyatt Corporation, that entity, employed this security officer.
Okay.
And we had 4 counts: negligent hiring, negligent supervision of that particular officer, negligent training of the other officers who were on duty, and negligent supervision of those other officers. So, and then I just go ahead and tell you, at trial, we had 2 experts. One was a forensic criminologist named Dr. Jane Gray from Ohio. She is wonderful. And Dr. Marilyn Hutchison. Dr. Hutchison is a forensic psychologist from here in Kansas City. Unfortunately, she's retiring at the end of this year, but she is amazing. And her background is specializing in sexual assault. And Dr. Hutchison spent most of her career testifying in criminal cases, battered woman syndrome type cases, and that stuff. But one thing that Dr. Gray testified about is that only 28 out of every 1,000 sexual assaults ever reaches the point of conviction. Now think about that. 28 out of every 1,000 across the country. And we talked to Dr. Hutchison about it, about just what's going on. There is a definite power imbalance in our society. And it has been ingrained in our society over the years that it's her fault. It's the victim's fault. She shouldn't have done this, or she shouldn't have dressed that way. And that kind of mess over the years has led to many victims shutting down and not coming forward, or not pursuing once they come forward. In this case, Shannon really had a hard time, like I say, as an officer, even speaking up that night or the next morning, much less in during the 6.5 years of litigation and 3 depositions and coming to trial. So when Marilyn Hutchison testified about it, she talked about a sexual assault, and the guy, the security officer who perpetrated this, did plead guilty in the case.
Okay.
And the criminal case. And he pled guilty to a sexual abuse, which I didn't know this before, but that just means he was in a position of power when he perpetrated the assault, and a burglary claim. And
both felonies?
No, he did. He got time served on his pre-trial, pre-plea, and he's registered as a sex offender for 15 years.
Okay. But
they weren't, nothing major there, which is a travesty in itself. But what Marilyn talked about a lot was that a sexual assault is the worst type of assault that could be perpetrated on a person, because of what it violates. It violates your sense of safety. sense of security, your personal space. When you once could walk down the street and feel okay, you lose that feeling because of what just happened to you. And from the most minor sexual assault to the worst things you can think of, they all involve that breach of privacy and trust. They all affect your future relationships and the way you deal with other people and the way you see the world. So that comes back to these things being reported. One reason I got so excited when Mike called is I think we need to be talking about this a lot more and a lot more publicly, because what we found out in this case is that the perpetrator didn't have a conviction history really to speak of, but he did have a history of arrests and investigations
For sexual assaults.
For various acts of sexual deviancy.
Gotcha.
All over the country.
Pattern of behavior.
He did. And the testimony from the corporate representatives of the company were that if they would have known of this pattern, they wouldn't have hired him. But the problem is, it's a lot of companies will only look at convictions. They're easier to find.
Is that cheap? It's a cheaper background check. Is that what it is? Or what's the,
I don't think it's that so much as it's just easier to get to. And from a corporate standpoint, I believe that it's easier to say, oh, you pled guilty to this, or you were found guilty of this. And you don't want to say, oh, you were arrested, but you were found not guilty, or the charges were dropped. Or the difference in our case was, though, this wasn't a one-time event in the past. It was a pattern.
Yeah.
It was a pattern over years. And that wasn't the only hiring issue. But it does show a pattern that this guy had towards sexual acts. They also, in this case, in the hiring, there were specific rules. One is a security officer must have a clean criminal history. Not a clean criminal conviction record, but a clean criminal history. He didn't. They only looked at a conviction record for 7 years. And what Hyatt had done is they went out and hired a third party to do the background check, and they told the third party what the parameters were. The third party didn't tell them. They said, hey, third party, we want 7 years, convictions only, and see if there is a registered sex offender. And then the company ordered this thing called like the worldwide search, had some name like that, that searched other jurisdictions. But this man had never lived in any of those other jurisdictions, so it didn't really matter. What they had not done, though, was to look for arrest records or investigation records. They also, there's a rule that employment background, 2 of the references must be checked and verified and signed off on.
Yeah.
That wasn't done. We had the documentation in the file to show that that form wasn't filled out and signed. And the other rule about that in the procedures manual was if it's not signed off on, if these aren't filled out and done, then the manager, the hiring director, can sign off on a waiver. And that wasn't done. And he testified at trial. He testified that was a deviation of their policies, the corporate policies. They also were supposed to do reference checks. They didn't do the reference checks, like personal references versus employment references. So that's the hiring claim in a nutshell.
Yeah.
Then when it came to the supervision and the training claims, so that night when the welfare check came in,
those are against other those are against other employees, right?
Yeah. So we had one negligent supervision of the offender.
Yeah.
And then we had one negligent supervision of the other employees, and then negligent training of the other employees.
Got it. So I'm just thinking proximate cause, like there's a little bit of a step here. Did you guys face any motions on that or anything like that? They were pretty cleanly lined up.
Yeah, we didn't face any. There were actually no motions on those issues at all.
Okay.
That I can recall right now. There's no summary judgment on those issues.
This wasn't the supervisor, this guy. He actually had supervisors or other coworkers that he was working with that evening.
That's right. There were 3 security officers on duty that night at the security desk. I think there were actually 4 on duty, but 3 at the desk at the time the call came in. There was the perpetrator, there was actually the least experienced of the three was designated to be the supervisor that night. And then there was a female security officer on duty. So the call comes in that there's a lady who's in her room who needs a welfare check. The guy who's sitting there as supervisor, the least experienced, dispatches the other male who happened to be this perpetrator, while the other lady, the other security officer, who's a female, went outside to smoke a cigarette. So the rule in their book says anytime there's a welfare check, two must go whenever possible. I think that the phrasing was shall go. Two shall go whenever possible. They only sent one, and they sent the male.
Man, that's a big problem. I mean, you've got a policy, and then you have, in terms of like steps they could have taken to prevent this, obviously not hiring this, sexual deviant is a big one, but then also, the other security officer might have said on her way out, no, that needs to be latched, or we need to wake her up, or we need to do something,
So that's the other thing. As a training rule, anytime there's a welfare check, you're supposed to wake the person up and make sure they're okay. Or if you can't rouse them or wake them up, call for medical assistance. So what happened was this security officer gets to the room. Sorry, I'm moving stuff around in here.
No,
so
that's
good. This is good.
He gets to the room and he goes there and he takes his, I got my keys on me.
Yeah, how's he get into the room? Because it's latched from the back.
Right. So first of all, he has like one of these key fobs, that we all have for different things. He's got one. It's a master key that opens all 920 rooms or whatever in the hotel. So he goes up, he swipes it, and it clicks against the security latch. So he gets on the horn with dispatch and has a maintenance employee come up. And you see this thing?
Yeah.
So that's the breaching tool for one of these locks.
It almost looks like a Slim Jim or something to get into a car that's locked. You slide it down the window. It's got a curve, and it's got a U curve in the end a little bit. It's interesting.
Yeah. So it's like it's like a tuning fork on the end.
Yeah, that's right. Okay.
And it's got these two little U's on each piece of the tuning fork that grabs the
the
loop.
Yep.
So you slide the Slim Jim. Thanks for that. I like that term. They slide the Slim Jim in and then shut the door, and it pops the security latch off.
It's that easy?
It's that easy. You can look this up on YouTube. There's videos showing how to do this.
And that can be purchased anywhere, that thing.
We got that one off the internet for $20 as we were preparing. Wow. And if you get on YouTube and search around, these two rubber bands, the large rubber bands we have in our offices, there's a video of a lady showing how to take a piece of duct tape and two of these and pop the same latch off.
Jeez. Okay.
Wow.
No one's safe anywhere.
No
right.
one's safe anywhere.
You're not. I tell you what, I've been telling my family members and people around me to take, I'm giving them all away that I have, but to buy a rubber door wedge.
Yeah.
And throw it in your bag.
Yeah.
When you travel, and just kick it under the door at night.
Yeah.
There's ways around that too, but at least it gives you something extra.
Yeah.
That's right.
So sorry. I know I ramble.
No.
But I mean, you're talking about like, Chris said, we're not safe anywhere, but it's interesting because if you go into a hotel like the Hyatt and you see 3 security guards, you almost have this sense of, I would anyway, of
a lot
of I feel really safe.
Yeah. And then they give you a key and they say, only you need to have this key and the door locks behind you. Yeah. And then you have a latch, and they call it a security latch. But then
maintenance is up there and he unlatches the thing, right?
Yeah. So the maintenance man comes up. Thanks, Chris. Yeah, I'm back on track. He comes up, he takes the latch off, and the maintenance guy just splits. He did his job. Yeah, he did his job. He left. So the security officer walks in the room, sees her laying there asleep. Now he knows she's asleep and she doesn't see me in the room. But he sees her asleep and he just backs out, shuts the door behind him, and says, and what his story was, look, they were worried about her being too drunk which she wasn't. But again, even if she was in her own room. She's an adult. She's in her room. But she's asleep and she's lying on her side. So if she's so drunk she throws up, she won't aspirate. She must be safe now. Let's let her sleep. So he says that and he shuts his door and everybody leaves.
Are there hallway? Is there video of this in the hallway?
No, the videos are in the elevator banks.
Okay.
Yeah. So he leaves and he, an hour later, comes back in, and that's when the attack happened.
Is there video of him coming and going on the elevators?
Yeah.
There
So there's two ways you put it together, and that's how they first found out what was going on. First of all, that little key fob and the electronic locks in the hotel. They can run what's called a lock interrogation report on any of these electronic locks anywhere you have them.
Mm-hmm.
And they put a little handheld computer thing to the lock, and it tells you every time it was opened and closed, if a key was used, and if so, what key was used. So they were able to take that report and show the time of the welfare check that this man's key was used. And then they're able to show again an hour later, it was used once to get in. And then the door opened and closed about 10 minutes later on the way out.
10 minutes?
Yeah.
He's in there for like 10 minutes?
Yeah.
Oh my God.
So that was what hit me too, Chris, and that's what really bothers her still today. She only knows about the last few seconds.
Yeah. That's frightening. Because, she wakes up, she may be like on Benadryl or some sort of allergy medication, so disoriented from that. She's been out with friends.
She'd had some drinks.
Strange place. I've woken up in strange places before and been scared myself. And like, where am I? What am I doing here?
Yeah.
I like when you were describing it earlier, I got this like chill down my spine and felt cold.
But does he have a gun?
No, he didn't carry a gun.
Okay.
He didn't carry handcuffs. He didn't carry a gun. They wore like executive security type, dark suits, dark tie, white shirt.
Okay. Got it. Yeah.
And I'll tell you this too. I wouldn't fault the hotel for having these
they need them.
Slim Jims. Yeah. They've got to get into rooms that are locked.
Yeah.
Right.
That if someone had a heart attack or a seizure or sometimes if you have adjoining rooms and one's closed and locked, they've got to use them.
Yeah.
Right.
But it was the procedure that was not followed, having two people there. Because if the female officer, and she testified, if she would have been there, she knew to wake up the person in the room and make sure they're okay or call medical assistance. If Shannon would have been woken up, she would have been able to relatch the safety latch.
Mm-hmm.
If you relatch the safety latch, you got to call somebody to bring the Slim Jim, the breacher back up to open the door again. So you can't get in by yourself. In this case, because the safety rules weren't followed, the several along the way, this allowed this man to get in, see that she was sleeping, see she was vulnerable, and then get back in with no one knowing.
Yeah. So then that's the claims to the negligent training, maybe on that young guy who sent the mail, and then the supervision on the young guy and the female who didn't go with him and supervise what was going on.
That's right.
Okay.
That's right. So all those things, and it's like they call it a calamity of errors. So many things went wrong, but they all went wrong because the company's not following its own policies and procedures along the way.
When is Shannon, the next morning we talked about earlier, she's starting to piece this together. Something isn't right. I think somebody was in my room, reports this to management. And does she go to the police or do they call the police?
Oh, they didn't call the police. So
they did not. Got it.
So this came out at trial. She comes down with her coworker. They go to the front desk and they say, look, let me back up. I'm sorry. I skipped a step.
Yeah.
That morning she called down to the front desk and said, was somebody in my room last night?
Oh.
They transferred her to the security desk.
No
the
way.
officer that perpetrated this answered the phone at the security desk.
The same guy.
Yeah. Of course, she doesn't know it.
Yeah. That's just...
But he answers the phone and she asks, was somebody in my room? He said, yes, I did a welfare check on your room. You were asleep. You didn't look like you were in any danger. Gets off the phone. So that's how she knows what was going on when her coworker
Okay.
came to say something. Then later, she's saying, look, I know somebody came and touched me. So the other detective says, we got to go report it. And like I said, she really didn't, she was afraid to, she was embarrassed to. She throughout this had a lot of trouble with being a police officer and being a victim.
Mhm.
Yeah.
How could this happen to me? She also, it really hurt her and still hurts her that it bothers her as much as it does. She's continuing PTSD treatment now. And the fact that she has seen so much, what she sees as being so much worse in the world in her job, she doesn't know why this bothers her so much.
Mhm.
And she's having a hard time connecting, like, it's okay to be hurt when you're a victim. She doesn't always have to be tough cop. And that's really, really hard for her. And it was hard for her to go report.
Mhm.
So they get there and they report to the front desk, and they get the security director, who has this lock interrogation run and sees that the man's key was used again. And he tells her, yes, the key was used again. And she says, can I have a copy of that to take to the police? And he said, no.
Huh.
He said, well, can I take a picture of my phone? He said, no, you're going to need a subpoena for that.
No kidding.
So they had to get in a cab. And I mean, you know how in cities, it's hard to figure out where you're going anyway with the different precincts. So they bounce around from precinct to precinct for a bit until they figure out who they need to talk to. And then the police had to go back and get involved in the investigation
Mm-hmm.
to bring it to light.
And that was, I mean, I'd be worried about the evidence disappearing at that point or whatever, stuff like that. I mean, who knows? So then it comes to light, but then when does she decide, is it further down the road that she says, all right, civilly, I need to get involved in this? I mean, I'm assuming this is a homicide detective is what she is, or she's on a homicide unit. Yeah. So she's, in my experience as a former prosecutor, like there's not a ton of females in that. And if they are, they're no bull. They are tough.
Yeah.
And they're usually the leaders. So she's sorting through all of that. And she's like, well, I guess I should get in touch with you guys. And then it goes from there. Or how much further out from time of incident do you get involved?
Couple weeks.
Oh, okay.
It was quick.
Okay.
It was quick because she had encouragement from her fellow officers to go find somebody. And an officer, like I said, was on the internet searching and handed her numbers.
Good.
And like sat with her and had her start calling. So,
Right.
That plus she was pretty frustrated. Criminal process sometimes runs a little slower than victims want to see it run.
Was your strategy to let that play out and see what he would plead to? And then were you worried about coverage issues, stuff like that? I mean, a lot of different balls in the air at this point and strategy wise.
There were, I tell you, that part was playing out quick enough that is the criminal process going to play out or not was really out on the outside of what we were worried about.
Okay.
We're always a little probably extra careful about not getting involved in that side of things.
Yeah.
But we were kept in touch with what was going on and knew what was happening. The coverage issues, of course, they were worrisome. If we were talking about that man as a defendant.
Yeah.
And he was a defendant for a long time. We made a decision before the trial to dismiss him because there wasn't going to be coverage for
on his non-covered claims. You get rid of those because the assault is obviously not going to be. If you have a direct assault claim against him, it's tough to hold him in coverage unless you can prove course and scope. And then they argue, well, he was outside of the course and scope once he entered that room to do whatever he was going to do. Yeah. So then you have these claims against the other employees and the training, and those are all covered claims.
Yeah. Well, I mean, the claims are all essentially against the company.
Yeah.
Flowing through him, flowing through the employees, all against the company. And those were all negligence claims.
Yeah.
And they all of those flow directly from breach of internal policies and procedures of the company.
We haven't really talked about this, but would you tell us all what the verdict was?
Oh, yeah. So the jury found $28 million in actual damages and $149 million in punitives.
Wow.
So it's my math that I did before this, that's 177 million. Is that right?
That's right.
Wow.
Now, there's a little small story about that I heard through the courthouse about the actual verdict form and the actual damages. If you want to share that with us, Wes, I think it'd be kind of interesting.
Oh,
I may have
is he
kept a
getting it
copy.
out?
He's
He's getting it out.
copy.
Yeah, this is perfect.
Hold on. Where is it?
I had it had escaped me that it was that big.
Yeah.
I guess I had forgot about that. That's
what
a
they
massive
did.
verdict.
Yeah. So what they did when the jury came back, and in all seriousness, they found in our favor on all 4 counts. They found for punitive damages on 3 of the 4, not on the negligent hiring claim, but on the negligent supervisions and training claims.
Mm-hmm.
Because it's nobody in the testimony, nobody could match up what they were doing with what the policies and procedures say.
Yeah.
It's like the police didn't know what's going on. So all 12 jurors unanimously found for our client in the first phase, the actual damage phase, and assessed $28 million. But like Chris was saying, so the judge reads it and he reads $28 million. The jury nods along. And we're thinking, let's get to the next phase. We need to get our ducks in a row. It's time to go. And I'll tell you this too, we were really shocked because generally, you guys know, if a jury comes back quickly, it makes a plaintiff's attorney's stomach hurt.
Mm-hmm.
Oh, sure. I would have braced myself for the worst.
It was just about an hour and a half
Oh,
when the jury came back. So we were feeling pretty sick. And our client by that point had been working as a courtroom bailiff in her home court. So she knew exactly why we had those looks on her face.
Mm-hmm.
So we're all thinking something went wrong. How do we mess this up? And then he says 28 million. Yeah. Well, I did that first part of closing where you asked for the amount, and I'd asked for 20 million. So we were pretty shocked. And I'm going to tell you how they came to 28, but we go outside and about 10 minutes later, our paralegal comes running down the hall yelling at me. And she's like, you got to get back in here. And I turned around and she hands me the verdict form. And she's like, look at this. And I said, what? She said, count the zeros, dummy. And I start, the jury foreperson had written 28 billion.
all the Hyatts.
Yeah. So we what happened was we went back in and our judge was fantastic about it. By agreement of all the parties, both parties, all the attorneys involved, we had him bring the jury back in and say, listen, when I read 28 million, that seemed to be the jury's verdict. And they were all shaking their head, yes. And he said, but when I checked, what's written down here is 28 billion. And they all cracked up laughing. And he said, what I need to do is ask each one of you to stand, and I'm going to ask you, which is your verdict, if it's 28 million. So he checked that way and he polled the jury by agreement of counsel, and we had him fill out another form to 28 million.
Got
Okay.
it. Okay.
And what we found out later is that the jury foreperson was just pretty excited and just wrote too many zeros.
Gotcha.
But it gave us all a small stroke.
Yeah. In a good way too, right? Or
Kind of the scary way.
and you're like, oh, are we losing this case? Like, is the case going to get mistried because of this issue? And yeah, boy, that's too much.
Right.
Too much for me.
Yeah. So then we had to calm down from that and then get Scott ready because he argued the punitive phase.
So at that point, though, had you had an offer on the case, or how did and how do you come up with 20 million? And I don't want to demean or diminish the damages, but in terms of a sexual assault, and I know you said they're all the same, but when I'm thinking about this wasn't a violent rape. It was still a serious breach of someone's physical surroundings, things like that. I mean, how are you balancing that? What are you thinking about the damages when you're coming up with that stuff?
So first I'll tell you, it's if you talk to Shannon,
Yeah.
and her family, and if you talk to her providers, her counselors, she's got 2 counselors.
Okay.
one that has her in an EDMR type therapy.
Yeah.
To help the brain spotting and EDMR. Another that's her counselor. It's been a long 6.5 years for her, and it's going to be a long future for her dealing with this. She can't, she's 43. She can't travel alone. She's only been out of town once alone since this happened. It was at the urging of her counselor, just to go take a trip, see how you do. And she had like a several-day trip planned to Florida. And after laying awake all night for 2 nights in a row, she just came home early. Her mother, shout out to Mama Dukes, but her mother's an awesome lady. She traveled with her to the trial just to stay in the hotel with her. We ended up having her testify because she was there.
Yeah.
She could talk about it, but she had to have, can you imagine being 43 and having to have your mama come stay in the hotel with you?
Yeah.
Well, when you said she went from on the homicide unit essentially to, and nothing against courtroom bailiff, but those are two different. I mean, those are in terms of action. That's a little bit different of where you're at.
It is. And she's had relationship struggles constantly since then.
Was she not with her child's mom anymore? Is that
She's
over?
not.
Oh, wow.
She's not. They split up.
Did
she's
she
a good
testify?
mom. No, she didn't. Her best friend, who's also an officer, testified. We did that via Zoom, which was interesting.
Gotcha.
Oh, really?
Yeah.
Okay.
Yeah, it was kind of terrifying at first because when we did it, we set it up through my iPad to a projector to a screen behind me.
Well, and I know that courthouse, the internet's not exactly the most reliable courtroom internet.
So the first 3 questions I asked her, the response came back like ordering at a drive-through.
Oh God.
Garbled.
And I'm looking, the judge is right behind the screen and he's staring at me like in a panic too. Like, what the hell are you going to do? And what I found out is on those Zoom feeds, and I'm not doing a good job of this today, but on those Zoom feeds, you really have to slow down and not overload the process.
Mm-hmm.
And once we slowed down, it smoothed it out. And her friend did a great job. Shannon did a great job testifying for herself about just how this has impacted her daily life. And one thing that Marilyn Hutchison, our forensic psychologist, said was, the tentacles of this type of assault just reach into every part of your life. And she said, imagine wearing a lead overcoat every day. And then every movement your body makes feels that weight. It might feel a little bit of weight here and a lot of weight there, but every movement feels the weight. And that's what emotionally and psychologically this sexual assault, the PTSD from the sexual assault does. And she also did a great job explaining how, PTSD isn't just a touchy-feely thing. It actually affects your brain. It affects the amygdala in your brain, how you're processing your fight, flight, freeze, or fawn. And you're stuck in those loops. And then you start to come out of it and you get a trigger and you go back. And she did a good job of just describing to the jury, both Shannon, her mom, her friend, and the expert, of just how much this affects everything. Mm-hmm. And it's not just I feel sad some days or I feel panicky in these moments. It's every moment of my life.
So I got a strategy question for you. So it sounds like the treaters did not testify.
What one counselor did by videotape.
And then you had your expert review that and the records and kind of get as almost like a summary witness and kind of explain and teach a little bit more. That was the strategy behind Marilyn Hutchison.
That's right. When in a case like this, you don't have x-rays,
Yeah.
You don't have real medical records.
There's no objective stuff to show. I mean, you've got psychiatrist notes, which, as we've all seen, they vary from handwritten to electronic records to almost nothing.
Yeah. And a lot of those handwritten records are shorthand.
Mm-hmm.
And for good reason. They're vague a lot of times. They're very carefully guarded.
Well, I've heard some therapists keep 2 sets of records.
Yeah.
The ones that are like the official and the ones of what they really think about the individuals and what's going on. It's crazy. So did you do like a medical exam with Marilyn Hutchinson and Shannon? Is that how you did it?
We brought her out here to see Marilyn. And again, she had to have someone come with her and stay with her, and which was good because Marilyn put her through a day of testing and then a time of in-person examination. So we had the type of testing that she can talk about credibility.
Objective. Yeah, you had so like those scales and stuff like that to show, hey, this is legit.
That's right. Yeah. And another thing in this case, the damages weren't contested really.
Okay.
There was no defense expert. There was no defense expert of any kind presented at trial.
What was the defense?
Well, you could do it right now. It was listen, that was a bad guy. He did a bad thing. We couldn't have known he did a bad thing.
Got it.
We did some sort of background check. But the bad thing he did was really bad. We feel bad when he touched her over her clothes. And that was the defense. And I don't mean to belittle it either, because the defense attorneys did a great job.
It's a responsibility defense. It's not our responsibility. We did everything we were supposed to do, and we're really sorry that this happened this way, but it's not our fault.
Yeah. And I think the defense attorneys did a great job. I really do.
Well, they're well-known guys. I mean, they're well-known. I've seen one of them in trial before in a big case over here. I mean, it's a well-known defense team.
Yeah. And they're great. Personally, I get along with them. I thought they did a great job at trial, but it was down to, are we going to say they had no way of knowing that all of these failures to follow their policies and procedures could have led to this or not? And in this case, there were so many ways. If one or two of the rules were followed along the way, this wouldn't have happened.
Mm-hmm.
But all the walls came down in protection when the rules weren't followed.
Yeah.
So well,
I guess.
Sorry, Mike. Go ahead, Mike.
I was just wondering, when you're, did you do the direct of Shannon, or did Scott do the direct of Shannon?
I did that one.
Okay. And so when you're getting ready with her, what's that like? And, what did you do to get prepared to do the direct? Because this is something that I know I wouldn't want to make them relive, but you have to do it.
And that's something you can't just pick up. Like, I can't pick up Mike's outline for that direct if I'm doing it and do it for him. There has to be a foundation for that relationship.
Yes.
Yeah. So, sometimes I'd say this case was snake bit by the pandemic and by the judicial system getting backed up. And Chris, in St. Louis, it got really bad because the lack of lack of jurors available.
They weren't coming in.
Yeah. We were supposed to try this back in May of this year. And just because of the criminal dockets and what was going on, there weren't enough jurors.
Mm-hmm.
So the good side of that delay was that we were able to spend a lot of time with her over the past several years on the phone, in Zoom conferences. Like I said, she was deposed twice in the civil case, once in the criminal case. She was here for the Marilyn Hutchinson meetings. Scott flew out for the first mediation. He flew out to her house. We had 3 mediations along the way. And so we got a lot of Zoom time, which I know isn't great, but it's okay. But a lot of phone time. And then when we got there, we started on a Tuesday. Monday was Columbus Day, no court, started on Tuesday. So we all met out in the suburbs at a hotel on Saturday afternoon and just spent time together. Just talked. Sunday, we spent several hours just kind of talking about the case and just getting into it. And then later on Sunday, when we felt comfortable enough, it was just, okay, we're going to do this one time and we're going to walk through what happened to you. And I pulled out the big blow up of the room that showed where the bed was, and we just walked through it and talked about it. And she was able to open up to us and really describe what had happened, and how that made her feel. And after that, we said, okay, let's don't do that again. Because we had to limit. I didn't want to just keep making it so raw.
Well, it also can lose its effect too if she can revert into a more rehearsed mode
Sure.
Like, I don't want to keep doing this, man. You're killing me. Let me just give you the, it takes away from the field.
Let's make it, she could, it's sort of like, let's make this vanilla as possible and protect myself,
Yeah.
and
And then what we did at trial is it was like a 24 minute direct.
Mm-hmm.
And I think with a case like this, with the injury and the damages like this, and having the counselor and the forensic psychologist and her mom and her friend to describe things, she didn't have to say it all herself.
Yeah. Got it.
And thank God. I would have hated to drag her through all of it again. So we could go right up the middle. Let's talk about what happened. Let's talk about how it's affected you. Let me sit down now.
How'd the defense do with it?
Good. Best you could do.
Yeah. Nothing.
probably not much
aggressive.
cross. Yeah.
There wasn't a lot. There wasn't a lot. And
She's testified before, I assume, in her criminal side, like as a reporting officer in other cases. I mean,
Yep.
this is not her first time sitting in that chair, obviously like this, but she's handled cross exams before in her past.
that's right. And she's a courtroom bailiff.
Oh
So
yeah, I
she's seen
forgot.
it.
Yeah.
But she did tell me it's a whole new world when you're sitting in the chair. I've done it. I know.
Me too.
Yeah.
I can speak from personal experience. Is a lot different than
Scary.
when
It is.
you're answering rather than asking.
Yeah, but she was so strong and so solid. And she was asked on cross, she was asked stuff like, so you still work, you're still a deputy, you're proud to be a deputy, you're not occupationally disabled by this. So no, I'm proud to be a deputy. I'm proud to do what I do, or an officer is what they call it.
Yeah.
You've got kids, you're raising your kids. It doesn't affect your relationship with your kids. And she's like, well, I try not to. I try to do the best I can. And she was just so truthful
Mm-hmm.
that it would have been hard for anybody to cross that effectively, because you
Yeah.
can't hide from the fact this is just awful.
Yeah.
So working up the damages model, is it a number that you just came to, or did you have jury research that you relied on, focus group research, or was it a number that you guys felt, hey, this is appropriate after spending all this time and doing all these things? This is what we think is fair.
So I'll tell you, we did do focus groups early on, and then again back in the summer.
Conducting your own or using a service or what?
We did our own.
Okay. And what was the feedback?
Not like this.
Okay.
The feedback wasn't like this, but we didn't do them in St. Louis.
Yeah.
We held back some things because we generally don't try to build up the damages on a focus group. We're just looking for issue spots.
Yep.
But as it got closer and closer, what we really started doing is just talking to people.
Yeah.
Anybody that would listen to the story, I'd tell them the story.
Mm-hmm.
I'd take out the names and just tell them the story and say, what do you think? What would you give? What would you, if you're a juror, what would you think? And I wouldn't put numbers on it. And it got to the point they're telling the story, the answers were coming back. What do they have? And I mean, I'm talking about, I called several of my friends who are defense lawyers. I called every good friend of mine who, lawyers and non-lawyers who are in this age group, who are female.
Mm-hmm.
Some that I know travel a lot. Then I would go call the guys, because I was worried about the different demographics and how it worked. And it got to the point where consistently the only people that were giving me lower numbers were plaintiffs' attorneys.
Yeah.
and I think that's because we always hedge ourselves,
Yeah.
But like, I call a defense attorney and run it down, and they're like, "Oh, you'll never see the courtroom on this. It'll settle."
They'll settle. Yeah.
And so that's how I started figuring it out, was I would just talk it out with whoever would listen, and then say, "What do you think?" And
did their settlement offers even get to seven figures or multi seven figures at all, or was it low six, or where they were just, or were they even serious?
They didn't get to seven figures before the trial.
They did not.
Never did. Not until after the trial was over and during deliberations. And then when you say seven, I mean, it was
Low.
Yeah.
Yeah. And then were you dealing with, in terms of that, were you handling it, or was Scott handling negotiations, or how did you guys, because I know a lot of people, and I think it's smart to divide it up sometimes. Or you just both handle it together?
We both did it together.
Gotcha. And then was it a general counsel or an adjuster? I mean, I'm sure there's layers of coverage. There's self-insured. Who you dealing with?
It was an adjuster from out of state.
Gotcha. Okay. Probably, probably looking for a different position at this point.
The adjuster, he flew in and stayed through the trial.
Oh, he did.
Hmm.
So he watched the whole thing, and as he was watching it, he didn't even adjust. Like, hey, this is not going, because clearly it had to be going. And I had heard through the courthouse it was going pretty well.
Yeah.
And he was not adjusting his claim with that. He was just kind of, wow.
I didn't really talk to him other than saying hello on the first day.
Yeah.
Oh,
yeah.
He talked to Scott right after closings, just for a second.
So what's reassuring to me about that, Chris, is that you have really good trial lawyers who get really good verdicts on a regular basis. And it's not personal to me that the adjusters don't want to talk to me.
Exactly. Yeah.
Oh shit. It's funny. When I first came back to work here, now all my friends here were like, oh man, everybody's just going to roll over. They're going to pay you on everything. And it's never has happened. It doesn't matter how many big hits Grant was getting.
It's like, you'll get this verdict and you'll probably, some defense lawyer will call you back, oh, everybody's sure paying you now. It's like, it ain't worth anything to anybody, but no one right now. No, it's not changing behaviors. I can't even get 25,000 policy limits. Like no one's paying. Like they're just not doing it.
Nope.
No, I mean, and we'll all, luckily that'll all keep happening to all of us because that's how we get to try cases.
Yeah. And that's how we make the most. I mean, that's how we do our best, right? We get the best results because of their mistakes. If it was fair, they wouldn't need us.
I tell you, if we would have tried the case 2 years ago, we would have probably asked for a different number from the jury. It was just learning and watching and retelling the story over and over that finally started building up the confidence to ask for a higher number.
And did you get this done on Friday? So you went Tuesday to Friday?
That's right.
And did you try any, I know everybody can talk about different techniques and things like that, but it doesn't seem like you had a ton of witnesses to get through, but it sounds like you kept them fairly short.
We did.
Okay.
We did. So here's the crazy thing. We had designated and fought out the designations on 19 different depots.
Okay.
We played 5. 2 of them were about 15 minutes long, but 3 of them were 2 hours, 2 hours and 20 minutes, and 1 hour 45. They were incredibly long.
Who were they? Were you worried about that a little bit, in length?
Yeah, we were. Typically, we only play a 45-minute depot or less. Yeah. What we did, it was Marilyn Hutchison.
Okay.
So our forensic psychologist, because when we were set to go to trial in May, she was going to be out of the country. So we took an April depot, and then it was so good. She did such a great job. We decided it's in the can. I don't want to touch it.
Yeah.
The other long one was the officer that perpetrated the act.
Yeah.
We didn't want him anywhere near the courthouse with our client.
Yeah.
So the depot was just long,
mm-hmm.
and it just had to be. And then it was her counselor from the East Coast that couldn't come in.
The treater.
Yeah. So what we did, it was great. The other side worked great with us. The judge was great about this. And what we do is we would play about an hour and then take a break. So we'd time them up around a lunch break or a morning break or afternoon break.
Mm-hmm.
And we just tell the jury, look, I'm sorry, but in these modern trials, we're going to do some stuff. We're going to do some TV watching. We're going to do some Zoom stuff.
But we're doing that. It saves time. Even though
in the end, it saves time.
Did you promise them you'd get them out by Friday?
We had to.
The judge said he said, hey, I'll get them out by Friday.
So when we had to reset it from May, our only choice was a 4-day window in October.
Got it.
And man, when I was sitting down, putting the original trial calendar together and all the witnesses, and I was like, I got it. And then I started looking at it, and there was no way to do it.
So you got to start at 6 a.m. and go till 10 p.m. to try and even get close.
Yeah. So we spent a hell of a lot of time in the week leading up to the trial, and then every night throwing depositions on the floor and saying, no, we're not going to use that. And man, that was one of the hardest things ever, because I'd like pick up a deposition. And I go, Scott, listen to this one quote I got this guy to say. This is so good. I did such a great job. And then I'd have to check my ego.
Yeah.
And throw it down and go, okay, that doesn't matter.
Yeah.
That's amazing.
Yeah. It sucked. Because
no, I know. I mean, we're like, when you see the extended cut on movies and the directors really want all that stuff to be in. Yeah. Kind of like, I really liked how it was presented, and I try to remind myself of that, because like you get these small victories, and at the time they're momentous. You get a doctor to say something that
when they're hard fought. You fought hard for them. Yeah.
And you're like, what are we, I can't give this up, but it sounds like you did the right, you made the right cuts.
So I tell you what helped so much, to brag on the one that's not here right now. Scott's the best planner I've ever been around in my life. He's the most organized person. I mean, it's scary at times, but he's so damn organized that when we first got the case in, and we both took a really special interest in the case, the whole thing kind of sickened me, and we wanted to see something happen. And we started looking at it, and we said, all right, let's get the right discovery out. So we tailored down our written discovery just to go for whatever policies and procedures we needed. And we didn't fight over stuff we didn't want. We didn't say we want every policy you've ever had. We want the ones about hiring security officers or doing welfare checks or using your keys. And we got those together. And then we set up depositions where, I think the first time we spent 2 days, I would take any fact witnesses like the other security officers. Scott was taking the security director and the human resources director. But we worked together to prep each deposition. And we knew the targets we wanted to get to. And we started with, we used TrialPad.
Yeah.
Uploaded everything to our iPads. Figured out our exhibit order we wanted at that point, and we went through the witnesses in the order we wanted to start. And then we got those transcripts back and started pulling the admissions. And we used that to then draft corporate representative topics. And then we went back. So then it takes, my hands are this, it takes this huge stack of pages of depots, and we narrowed them down to what can we do in these corporate rep depositions. Those admissions. What happened was the security director and human resources director became the corporate representatives for the next set of topics. So we could just take their admissions and walk right down them. And
that they gave as fact witnesses that you now used as corporate for them in their corporate rep depots.
Yeah. So we took 2 sets of those. So each one of those witnesses was deposed personally once a piece and twice as corporate rep. So we had 3 depositions of each one of these directors. And we had them designated to play at trial because, again, we thought, man, these are great depots. We, pat yourself on the back.
Yeah.
Right.
And the decision we made to really shorten it up and have the best impact was we decided to call them both live in our case and cross-examine them.
Oh, yeah.
And Scott, the way it really worked out, we pulled together, Kevin Buchanan in our office was working with us on this case, and he did a great job of going through everything. And he pulled out every great admission from these 2 all the way through their personal depositions, their corporate rep depositions. And then we had video clips made of every question and answer that was a good admission.
You played them as admissions at the trial?
We had them ready.
Okay. If they didn't answer the right way.
Yeah, for impeachment.
Gotcha.
So we had them ready, and our outlines then were numbered. Like if it was clip number 54, it's ask this question, then clip number 54.
Yeah.
We only had to use that one time at trial.
Who was running the trial pad at trial? So like you knew, hey, if I did this one and we, well, sir, we've got, and once it hits once, they're like, oh shit,
so we had I got to think. We had somebody helping us with trial tech that was from out of town.
Oh, okay. Got you.
But what we did when I have a witness, I'm running my own trial pad. When Scott has a witness, he's running his. But for videos, we use the trial tech.
Got it.
Because there was just too many clips to keep up with.
So you had the clips numbered with them, so they knew what to play. You just told them.
Yeah. So So what, we'd start out with Scott was going to call the human resources director on day one. So he calls him and he says, you're being called here as a witness pursuant to, and I can't think of the statute right now, but it's the Missouri statute that allows the adverse witness. And he said, do you remember me taking your deposition a few times? He said, yeah. So Scott stacked the copies up in front of him and got into his outline. And the first time the answer was not quite what we had said before, he says, okay, please play clip number 54. Mm-hmm. And on the big screen, the guy answering the question in the opposite fashion pops up.
Same guy.
Yeah. And their security director.
That's great. I mean, I'm looking at Chris too, because you got the same smile. That's great, man. That is.
It was so cool. It wasn't an original idea from our office. I can promise you that.
Yeah.
But it's great because once you get that the one time, that guy or that gal, whoever's on the stand, is now scared shitless. They don't know what you got because they can't remember what they said. And clearly you're way ahead of them. So now it's like, all right, I'm just gonna, whatever you say, guys. Yep. And
it worked out great because the security director was the representative for trial, and he was sitting there watching this happen.
Oh man.
So after that, when Scott would ask a question, you get a yes, true, and correct. And we all of our questions are crafted to things that were already admitted to before.
Yeah.
So I mean, here, I just got to go through some of these real quick if you don't mind.
Yeah, absolutely.
So like Scott asked that the human resources director, the hotel employees didn't vet him according to Hyatt policies with respect to work history and references, meaning they didn't do the reference check. The answer, correct. And so you agree Hyatt's violation of the process as to work history and references allowed them to hire a sexual predator. True? True.
Wow.
So these things are coming out through the human resources director.
I mean,
that's day one.
Yeah, so you're not having to beat a dead horse.
Yeah,
you've got it.
So that night we're driving back because day one of trial, my truck broke down. So I was riding in and out with Scott every day.
Yeah.
So we're riding back to the hotel, and I said, "Hey, we've got to do that tomorrow with this other guy. We can't play the deposition; it's too long. What you did today was too good. We got to do it again." And he just looked at me and said, "Fine, but you have to do it." Okay.
Okay.
Challenge accepted.
Yeah.
Which honestly made me sick of my stomach because he had done such a great job on cross that I knew I had to do. He's got 15 years of experience on me, and I've got to do as good or better the next day to keep things going well. If I screw this up, but thank goodness he trusts me. And he helped me kind of put things together, and I did not sleep that night.
Yeah.
But we got in there, and I called that security director who was a corporate rep, both at trial and had been named corporate rep. And, without objection, I asked, due to the many breaches of Hyatt's policies, Shannon Dugan was sexually assaulted in her hotel room. He said, correct.
It's admission of liability. I mean, it's right there.
Yeah.
Slammed him. Like,
then we're on the, I never really know how to say this, but because I put him on first, but I did the cross. So then on direct, I guess.
Yeah.
The Hyatt attorney hits this one section. And he said, well, let's talk about lessons learned. What lessons did Hyatt learn through this? And the security director said, oh, well, we do things differently now. And basically he went through a list of policies they follow, which were all the policies they breached in our case. And
so
I see that look on your face, Mike.
Right.
And I think the strategy would be, hey, look, if we're going to get a negligence, we're going to take the punitives off by saying we've changed our ways.
Yeah.
Right.
Yeah.
But boy, that's dicey.
Yeah.
So on the recross, the last few questions were, when you say the lessons are learned, those lessons came at the expense of Shannon Dugan, didn't they? Correct. She had to go through this horror. She had to go through the sexual assault in a private room for your company to learn these lessons, correct? Correct. The lessons learned were already stated in your rule books the lessons that you already knew as a company, but they weren't applied until she had to pay the price, correct? Correct. And saying these lessons are learned, are you, on behalf of Hyatt, are you accepting responsibility for what happened to Shannon Dugan for her sexual assault? He said, yes.
Wow.
So
They're
those
trying
were,
to ameliorate, mitigate, but
Yeah,
that's
you
not.
can see you can see what they're trying to do, but I mean, you got a multi-billion-dollar company, right? Or whatever they are. I mean, it's hard to,
That's dicey.
yeah.
so, when you ask about how it all came together, and, people are asking me, well, how did you do that 2 days of evidence? It was taking, it's like making whiskey, right?
Yeah.
The mash is huge, and you distill it down to or you cook it to the beer, then you distill it down to the alcohol. We had to take all the information and, thank goodness Scott's such a great planner.
Mm-hmm.
And we were able to plan it out from the start and then start walking it through step by step until those answers came out. And I bet each one of those crosses was a 20-minute, 25-minute cross.
Yeah.
And so
Hit it
effective.
and move. Yeah.
I mean, just bang, bang, bang.
$177 million. And with the interest rates, that seems to be some pretty good post-judgment interest on that. It'd have to be close to 8%, right?
Yeah, it's over 8%.
It's over 8%.
So, I was just talking to a buddy of mine. The way the interest rates are, this is the first time in years we've had good interest rates.
Yeah.
We're almost back to the post 2005 rates.
Yeah. That's
Or pre
it's
2005.
incredible, man. And I mean, I think I speak for Chris and for everyone listening. You guys, well, one, I learned a lot. I've learned a lot, especially just doing an adverse cross like that. That's incredible. But also, I mean, she picked someone out of the numbers and she picked the right team. So congratulations to you.
Thank you.
And I hope this has given her a sense of restoration to whatever degree it can.
I really appreciate it. I hope for Shannon, I would never want to speak for her, but I hope it helped a little bit in validating what she's been through and letting her know and letting other victims know that these things are important and they're awful. And we need people to support victims so they can come forward in the future, and it starts with attorneys like us.
Mm-hmm.
We need to tell everyone, when you're a victim, you can come talk to us. We'll help you in the process. We'll help you report it. We'll help you prosecute it. We'll help you fight the bullies.
Yeah.
And I really think that's some good that can come from the whole thing. I do hope.
Yeah.
Well, congrats and thanks for coming on. I mean, this has been just an incredible story build up and really appreciate you sharing it, Wes. I know you got post-trial motions are probably pending. If they filed theirs and you guys can respond. And
so there's a new trial motion pending. We're working on the response and it'll work through however it works through,
Yep.
That's just part of what we all do. But I know that just where we are now, we can get the word out about things.
Yeah.
About how important this stuff is.
Yep. Absolutely. Well, appreciate it. And congrats again to everyone on the team. And just grateful that, she got a good lawyers like you all to fight for in court.
I appreciate it. One other thing I'll say is, it's not, well, I'll say it this way. It's much easier to do what we do in Missouri because we have such a good group of plaintiffs' attorneys in Missouri.
Yeah.
I say it's now because there's 3 of us on here, but MATA is such a close group and such a sharing group with each other to be able to, I could pick up the phone and call guys all over the place. And especially the female plaintiffs' attorneys in the Kansas City area that are good friends of mine that I could call and bounce ideas off of because some of this stuff was hard for me to realize how to discuss, how to talk about. And the fact that we have that group in MATA in Missouri that can do that stuff is pretty dang cool. Makes us pretty fortunate.
Yep. Well put, man.
Yeah, thanks. I sure appreciate it, guys.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
Wow, that's amazing. It's incredible.
I think, we did a little over an hour talking to him. I don't think we could do enough. There's so many issues we could have gone into about how they made those decisions, how they cut back on things, and then, the damages, how they put them forward. We kind of got into it, but we could have done a ton more. It's just incredible what those guys did.
You could certainly parse a lot of things apart, and we also have to be mindful, just like they were mindful of getting things to the jury in a concise fashion. But I have a ton of questions about what they decided to cut out and what that process was like for them mentally, because for me it's very difficult.
Yeah, absolutely. So I think that was incredible to listen to, and one I will be listening to a few times there over.
Yeah, and you're like you said, you're getting ready for this trial. You got to get the stamina built up, know, and so you listen to this, you listen to some other podcasts to get that sort of in your mental space. Got a quick question for you though. Is there anything that you do? I know you're a runner. It gets cold this time of year, right? So I'm
on the Peloton these days.
Are you? Is that what
Peloton,
it is?
Peloton and the weights, and that's the routine, I guess, is to try and do something each day.
Yeah.
I don't know. What about you?
Yeah, no, none of those things. I know. So I've gotten into the habit of eating a salad every day, or some sort of leafy green. And, so fortunately I've dropped like about 20 pounds.
Fantastic.
One of the other things I found out is that, if I don't do that, or if I don't get some sort of healthy, nutritious meal in, I'm out. My brain is zapped.
Yeah.
And so, Tad and I did this podcast with this nutritionist, and she talked about getting her husband ready for trial with food.
Yeah.
And I really adopted a lot of that stuff, because if I'm eating a salad, if I'm eating healthy food, I find that I'm keeping pace,
and then also for me, drinking a lot more like tons of water. And I know this sounds weird, but these things called water drops, they actually like
meal. Water.
Yeah, kind of like meal, but they're lightly flavored. They help me drink a ton more water.
Do they really?
They're little cubes. I got to show you. It's a little.
So it's like drinking lemonade. Oh, okay.
No, it's like even less flavored than that. It's not very sweet, but I buy bunches of them, and my wife got me onto them, and I'll chug those.
No kidding.
Because sometimes water can be tough to really get down, but especially when it's cold, this is no problem.
Yeah, I got it. So I try to do.
Because you're a big coffee guy.
I am. I drink a lot of water though. I drink. I walked into a coffee place yesterday. I was like, "Hey, can I have a glass of water?" And I chugged it in front of them and sat it down. They were like, "Do you want any more?" I was like, "No, that'll tide me over for about an hour." So, but I force myself. But I do need to get into that. A routine of physical exercise, because for lawyers like us who go into court, it helps. We have to have that stamina, physical and mental.
Well, it helps get you clear out more as you do it. You come up with different ideas and stuff like that. And I think it's got to be part of the regimen for sure. Yeah.
Glad to be back on. Glad to have such an awesome guest join us. And I'll talk to you next time, brother.
Sounds good.
That concludes another episode of Case Autopsy, the Verdict and Settlement Podcast. Part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.